I hope that we are live. Let's see, let me adjust a little bit the camera here so our heads are not cut off here. Welcome everyone. This is Lenka and Doug. So we will be waiting a few moments for people to tune in. We are doing live. So if you are on replay, you know already what to do. And today we are bringing you another exciting part of our mortgage fraud series. So if you are involved in this professionally, personally, or just curious, this is definitely something you want to hear out. So welcoming you all. We are just waiting for people to tune in, and we will be starting with some questions in today's series. So this is the 7th part of the series. These are educational series. These series are to make you think, to make you go and research on your own. Don't take anything we say, go to do your research, involve your critical thinking, make sure that you really sit down with this information and start digesting. And if this is your first time with us, make sure that you go to the previous series that we've done. Like I said, this is the 7th part. We started maybe 3-4 months ago with these series, so it's been kind of ongoing, and it will keep going, because I think this is we are at times where we have to really realize that all the history books have been written by the conquerors, right? Who conquered, who manipulated all that information. And so for that, there are the public schools, right? That they just take all the kids through and they teach them what they want them to program them with. Thank you so much, Doug. And so we are doing these series to really bring the truth to the surface and educate people on the truth, on really what happened with our country, what happened especially with our monetary system, what happened with our court system, what happened with our educational system, what happened with our food system, you name it, okay? Everything, everywhere you look, we pretty much are living in pretty scary, corrupt world, well built on fraud. All right, so this is only for the brave souls. Okay, if you enjoy to be a slave, if you enjoy just to go with the flow, this is not for you. There are plenty of channels out there. So but if you are a critical thinking, if you know down deep in your soul that something is just not making sense, it's not making sense. And this is why your soul is waking up, and it's literally asking you, it's searching for the truth, it's searching for the information. So anyway, this was my little chit chat before we got people on, making sure that we are live. And so in today's part 7 series of the mortgage fraud, we will be asking a few questions, okay? And we will be actually showing you how deep this fraud really goes. And today is really focused on the counterfeit securities. So we've talked about the mortgage, we've talked about where it starts and all that stuff. So, but do we really know what's going on at the closing? So you saw this great house, they showed you the land, right? And you spent all this time going through all this paperwork, and they could just keep shoveling more and more papers and sign here and autograph there and initial here and initial there. They don't even give you the time to review these documents. It's just shoving all these documents through your throat to basically keep you busy. And you already see yourself in this new house, right? And they just keep shoveling these documents. So do we really know what's going on at the closing? Are we ever told who all the participants are in the entire process? I don't know how many real estate transactions you've been through. I've been through several, and let me tell you, there are teams and people and escrow companies and title companies and realtors, right? And inspectors, and it's just this kind of like revolving door. But are we truly given full disclosure of all the various aspects of that entire transaction regarding what, for most people, is the most largest purchase they will ever make in their entire life? So we will start with the very first part of the transaction. Okay, we have a virtual stack of papers placed in front of us, and we are instructed where we are supposed to start signing or initializing on those closing documents. There seems to be so many different documents with even legal language that we could read for hours, and we could spend days, right, and sometimes even weeks just to go through them the first time, much less begin to fully comprehend them. But are we given a copy of all these documents at least 7 days prior to the closing so we can read and study these documents so we can fully comprehend what is that we are actually signing? Are we agreeing to everything we are signing? Well, first of all, we would have to comprehend it, right? And most of the times we just trust, hey, you know, this is a recommended agent, this is a recommended escrow officer, and we think that these are professionals. They've been doing this for so long time, right? So we most time do not question. But that has never happened to the average consumer and purchaser of property in the last 30 years that a full disclosure was actually given to what is going on. Do you ever ask why? Why they don't actually explain it to you in lame terms and give you full disclosure? So we have a stack of documents placed before us at the closing that we haven't even seen ever before, right? And we are instructed where to sign and where to initial to complete the transaction and get our new home. We depend on the realtor agent and, as I mentioned, all these other people that are involved in this transaction. But we have 3 days of right to rescission that we can cancel. But if we don't truly comprehend what's going on, how can we cancel something we don't understand and we just put our blind trust in it? So we will be kind of taking you, we have some notes here, very important notes, what's really going on and some of the additional violations, major violations that these companies are doing. So Doug, do you want to put your few cents into this?
Well, what they're doing is they're creating counterfeit securities, and they're actually distributing counterfeit securities without, they don't really know what they're doing. And they're not disclosing any of this stuff to the people before they sign or even after. So you can't have a valid contract without a meeting of the minds. And if you don't know about it, there's a thing called the law of discovery. Especially with fraud, how can you know about fraud until you discover the fraud? You know, and then it's not just discover the fraud, you've got to get evidence of the fraud. So you have to actually know what you're doing when it comes to these kind of things and what's required of them and what's required of you. So like I say, it always starts with the so-called loan. If there wasn't anything of substance loan, then there's nothing of substance owed. And then we progress from there to now they've got you signing a note and they're securitizing the note. So, you know, is that lawful? Is it legal even by their standards? I don't know, you tell me.
All right, thank you. So now what we will do is, and we've already established that fact in some of the other videos. So let me read you part of these notes that we have here in front of us. Some of the cases as well that's been already well ruled by many of actually the brave judges out there. Thank you so much for standing up and speaking out on these frauds. So let's go to the deed of trust first, okay? So why do we need deed of trust? What exactly is a deed of trust or other similar security instruments? It spells out all the details of the contract that you are signing at the closing, including such things as insurance requirements, preservation and maintenance, and all the financial details of how, when, where, and why you are going to make payments to the lender for years and years. But wait a minute, the lender make payments to the lender? Why do we have to make payments to a lender when we just learned that all they are doing is they are accessing our trust accounts because they have the monopoly on it, and then turning around and lending us our own credit. So why do we have to make payments to this so-called lender? Didn't we just establish that fact? Yes, we did, right? So is there something wrong with this picture? Like, so what's really going on? What are they doing? So we have just paid for our home, okay? Because your autograph on that note, on that promissory note, is funding the loan.
Well, that's where you need to get into the definition of a loan and a lender. And so, you know, what it's doing is they're monetizing your instrument through a deposit, okay? And they've got a monopoly on the monetization of these so-called instruments. So you can go in and fill out a promissory note, right? Mm-hmm. And they can deposit that promissory note, okay?
With their bank.
Mm-hmm. Now, then they loan you back your own credit. Actually, what they do is they do a banking transaction. So the deposit is an asset to the bank, okay? But there's a liability because it's a demand deposit, because you didn't just give them your instrument. You believe that you're getting paid something of theirs, and you're doing the instrument to cover what you owe them because they actually gave you some substance of theirs.
Right.
That's what a loan is. But now I turn around and go, hey, you want to borrow $10? Mm-hmm. And you say, yeah. Say, okay, well, hey, can I get $10 from you? Okay, thank you. Oh, here's $10, and you owe me $5 in interest. Okay, this is what they're doing.
Right. And remember that banks cannot loan their own credit or their customers' depositories credit, basically, okay, under the federal law. And in the federal courts, it is well established that the national bank has no power to lend its credit to another by becoming surety endorser or guarantor for him. This is a ruling in Farmers and Miners Bank versus Bluefield National Bank, 11F 2D 83 271 US 669. A national bank has no power to lend its credit to any person or corporation. This is Bowen versus Needles National Bank, 94F 925 36 CCA 553. Let's see. So what is happening with the deed of trust or similar security instruments that says we have to pay all this money back, and if we don't, they can foreclose and take our home? What's going on here? But why don't we have some kind of agreement when we have already paid for our home through our mortgage note, which was converted to money by the bank? Could this possibly be another example of studied concealment and misrepresentation?
Well, it's constructive fraud. And see, once again, it's all constructed on the basis of there was an unauthorized act of Congress, House Joint Resolution 192, Public Law 7310, and that it changed our monetary system. So it revenued us, okay? And so everybody thinks they're in this, constitutional republic and all of this kind of stuff, right? And then they changed it into saying democracy, okay? But what we're really in is corporate fascism, because all these are nothing but no-till corporations, okay? And they've allowed themselves to operate in a voluntary bankruptcy through that unauthorized act of Congress, which took all the money. And since it took all of the money, it put the people and all of their sweat equity and their future labor and everything else up as assets and surety for the debt. And so, they look at you as debtors. In a bankrupt society, there's only creditors and debtors. And so you're either a creditor or a debtor. and they've got you down as a debtor through the Social Security and the other things that can be fixed. I mean, you can, there's things that you can do that can correct that status and to what it's supposed to be on paper. But I mean,
so, but let's talk back to the deed of trust and the similar instruments that happen. Where does it go after we sign it?
A deed of trust. Okay, where's your deed? What deed? The only deed that you're supposed to have presented to you near closing is the warranty deed, warranting that nobody else has title to that property. Okay, so where does the trust come in? Okay, and then you've got MERS, and then you've got.
We will talk about it in a little bit later on.
You've got Fannie Mae and Freddie Mac.
Where did they all come into the party? I don't remember.
No, they're the ones that are the beneficiaries.
Right.
You know what they've done is they've created a trust, and you're not even a part of it. You know what I'm saying? And then it's a REIT, so it's a real estate investment trust. Okay, so I mean, you know, they did all of that through sleight of hand.
So let's go back and let's see all the players here. Okay, as we mentioned, now we have a trust, now we have a MERS, and all this happening, right? So it's getting very nicely packaged, and the fraud just keeps expanding because there's a lot of people who have their hands in the cookie jar here.
Well, they built
the whole infrastructure around it.
Infrastructure. You've got the escrow market. You got all the escrow companies, title companies, real estate attorneys. Real estate agents, they're all, each one's a compartmentalized part of this great big constructive fraud.
Yeah, this scheme. Okay, so let me continue to mention the notes here, read from the notes. So we've already found out that the note doesn't go into a vault for safekeeping, but instead is deposited into an account at the bank and becomes the money, right? Where does the note go then? This is the this is where things get very interesting, because your mortgage note is then used as access your treasury account that you know nothing, of course, about, and get credit into the in the amount of your mortgage note from your prepaid treasury account. If they process the note and get paid for it, then they have received the funds from your account at Treasury to pay for your home. Right? That's what exactly happened. They then turn around and bundle the note and sell it to investors on Wall Street and get paid again.
Yeah, hedge funds.
Seriously? Seriously? Now, let's see what happens to the deed of trust or similar security instruments after you have signed it. You might be quite surprised to know that not only does it not go into safekeeping, it is immediately sold as an investment security to one of any number of investors tied to Wall Street. There is a ready and waiting market for all of the mortgage paper that is produced by the banks.
That's what the mortgage-backed securities are.
That's right. So what happened is deed of trust or other similar security instrument is bundled and sold to a buyer, and the bank gets paid for the value of the mortgage again. Haven't the bankers just transferred any risk on that mortgage to someone else, and they have their money? Action has the liabilities. Is there something? Yeah, being interrupted. Go figure. How can it possibly be that the bank has now been paid 3 times in the amount of your perpetuate mortgage? How is it that you still have to pay years and years on this perpetuate loan? Was any of this disclosed to you guys before you signed the deed of trust or other similar security instrument? Would you have signed any of these documents, including the mortgage note, if you knew that this is what they are actually doing and that this is actually funding the purchase of your home? Do you think that there were any copies of the mortgage note and deed of trust or other similar security instrument made during this process? Are those copies just for the records to be put in a file somewhere, or is there another purpose for these documents? Now we get into the really juicy stuff. Can producing a note or deed of trust be illegal? We have already established that the mortgage note and the deed of trust or other similar security instruments are securities by definition under the law. Securities are regulated by the Securities and Exchange Commission, which is an agency of the federal government. There are very strict regulations about what can and cannot be securitized. There are very strict regulations that apply to the reproduction or copying of the securities. The Counterfeit Detection Act of 1992, Public Law 102-550 in Section 411 of Title 11 of the Code of Federal Regulations permits color illustrations of U.S. currencies. And let me go here, but now we go into some really great stuff. So let me read you Title 18 of the United States Code 472, uttering counterfeit obligations or securities. Whoever with intent to defraud passes, utters, publishes, or sells, or attempts to pass, utter, publish, or sell, or with like intent brings into the United States or keeps in possession or conceals any falsely made, forged, counterfeited, or altered obligation or other security of the United States shall be fined under this title or imprisoned not more than 20 years or both. Okay, and that's exactly what they are doing. Title 18, United States Code 417, dealing in counterfeit obligations or securities. Whoever buys, sells, exchanges, transfers, receives, or delivers any false, forged, counterfeited, or altered obligation or other security of the United States with the intent that the same be passed, published, or used as true and genuine shall be fined under this title or imprisoned not more than 20 years or both. And Title 18 U.S.C. 474, plate stones or analog, digital, or electronic images for counterfeiting obligations or securities. Whoever with intent to defraud makes, executes, acquires, scans, captures, records, receives, transmits, reproduces, sells, or has in such person's control, custody, or possession an analog, digital, or electronic image of any obligation or other security of the United States is guilty of a Class B felony. Are these regulations always adhered by the lender when they have possession of these original securities and make reproductions of them before they are sold to investors? How much has been in the media in the past several years about people demanding to see the wet ink signature note when there is a foreclosure action initiated against them? You hear all the time. Why is that such a big issue? Shouldn't the lender be able to just bring the note and the deed of trust or similar security instrument to the court and show that they have the original document and are the holder in due course and therefore have a legal right to foreclosure? To foreclose, they must have, meaning the lender, must have both the mortgage note and deed of trust or other similar security instruments, original documentation in their possession at the time the foreclosure action is initiated. Okay? Furthermore, is there a real honest to goodness obligation to collect on? Why is it that there is such a problem with lost mortgage notes, as is claimed by numerous lenders that are trying to foreclose today? How could it be that there could be so many lost documents all of a sudden? Could it be that these documents weren't lost at all, but were actually turned into a source of revenue that was never disclosed as being part of the transaction? To believe that so many original documents could be legitimately lost in such a short period of time stretches the credibility of such claims beyond belief. Now we go to the really interesting part. Could this also be the reason for MERS? Okay, what is MERS? MERS is a mortgage electronic registration systems. Okay, which was formed in the 1990s as a way to supposedly transfer ownership of a mortgage without having to have the original documents that would be required to be presented to the various county recorders. Wow, wow, wow. And it's so funny, right, Doug? How many times do they refer to MERS and RESPA and all those like that's like some kind of law?
Well, they lean on that. I mean, that's what they lean on to be able to do what they do, and none of it's lawful or even legal because they're required to have the originals. Because without possession of the original wedding signatures, there is no original contract. And a copy of a contract is about as good as toilet paper. Right. And whenever that note separates from the mortgage, now it's null and void. And that happens every time they securitize. All the time. Every time they securitize. Like what you have to think of that note is it's like a check. Okay? It's a check that goes into a bank. So imagine that you would write a check, right? And then you would continue to be making copies and copies and copies of this check and would be giving it to other people, okay, to go and buy stuff with it and give you something in return for it. Would that work? No. Would that work? Would it work, people? No, that would be counterfeit. Wouldn't that be called a counterfeit security? I think it would be called a fraudulent check, but yeah, well, but whatever. But that's exactly what they are doing. Okay, so. Who was it that produced the counterfeit securities? Who was involved in taking the counterfeit security to the court to file the foreclosure action? Who was it that is now legally in possession of that counterfeit security? You need to really ask that. Who is holding the security document? Like the counterfeit security document. Company. Like your mortgage servicing company, and they just keep passing you like a hot potato. What was the latest, the funniest? Mr. Cooper. Yeah, Mr. Cooper. Oh, and we got another one, right? Our hot potato was passed to Shell Point. Yeah, Shell Point. Wow, which is actually one of the original lenders that created a shell company. It's extension of who? New Res or? Yeah, New Res. New Res. It's hilarious. Yeah. So anyway, you need to ask, who is holding this counterfeit security, okay? That's reproducing basically this check, okay? Has everyone from the original lender down to the clerk of the court where the foreclosure is now being litigated, being in possession or is currently in possession of that counterfeit security? You need to start asking questions, people, okay? What about the trustees who are involved in the process of selling foreclosed properties in non-judicial states? What about the fact that there is no judicial proceeding in those states where the documentation purported to be legal and proper to bring a foreclosure action can be verified without expensive litigation by the alleged borrower? All the trustee has to do is send a letter to the alleged borrower stating they are in default and can sell their property in public auction. It is just assumed that they have the original documents in their possession as required by law. In reality, on most every situation, they do not. They do not. They are using counterfeit security as the basis, okay, to foreclose on a property that was paid for by the man or woman who signed the promissory note to begin with. Okay, so people, I don't know about you, but how about all those people, the hardworking men and women that lost their homes, okay, through all this crap, through all this fraud being played on them, through the entire system, the entire infrastructure that's been built.
When it is demanded they produce the actual original signed documents, they almost always refuse to ask so and ask the court to take their word for it that they both have one of the original documents which are absolutely required to be in their possession to begin foreclosure action. Okay. What else do we have here? Oh, let's go into this one. Okay. Has any of this foreclosure activity crossed state lines in communication or other activities? Have there been at least 2 predicate acts of fraud by the parties involved? Have the people involved used any type of electronic communication in this fraud, such as telephone, faxing, or email? It is obvious that those questions have to be answered with a resounding, of course, yes, right? And if that is the case, then the fraud that has been discussed here falls also under the RICO statutes of federal law, okay?
Good old RICO.
Yep. What else do we have here? I think we pretty much covered some of the important points. So we have system of constructive fraud. We have of course mail fraud. They are using United States Post Office mail, USPS or USPS mail to extort, to threaten, to coerce.
Well, once again, it all deals with the APN number.
Oh, and then of course it deals with the APN number because that's all based securitized, okay? That's all based on the legal description which falls under the APN number, which is the overlay over the actual land, the actual dwelling, the actual private property. Do you have anything else to add on let's talk a little bit about the RICO violations. What is RICO, Doug? Just recap for us, please.
Racketeering influenced criminal organization. What it is when you have a criminal organization, which is, say, a corporation's acting outside of its charter, and it's involved in some type of fraud, scheme, scam, okay, and it's defrauding the people, okay. So what happens is the people can come in because nobody else will do it, right? And they can prosecute their own RICO. And if there's...
They would become the private attorney general on that case, right? On their case.
Yeah, under 1988, 42 USC 1988. But the thing about RICO is, I mean, it's so broad, and it's made for people to become their own private attorney generals and prosecute the cases that nobody else, like the corrupt courts and the corrupt prosecutors and all that, don't want to prosecute. So you can go in and prosecute them under RICO, a civil RICO, and then if you win, you get paid 3 times the damages, and you get paid attorney's fees and all this other stuff. And what it is to snag people that are involved in any type of criminal activity that's listed under the RICO Act, and fraud, constructive fraud, extortion, embezzlement, robbery, all of this stuff is listed in there. And if there's 2 predicate acts within 10 years that can be proven to further their little organization and their organization's profiting from it, they can be prosecuted under RICO.
Wow. Yeah, it's incredible. So this is what we need to, this is just so fascinating, when you start really learning what happened to our monetary system, right? And what happens at the closing of the escrow and all the parties involved, and actually what's happening, and how easily it is for these criminals to continue in their system of constructive fraud. It really comes to the knowledge that you people have and the ability to expose the fraud and defend your rights.
Once you expose the fraud with the evidence, And, there's ways of doing it with your paperwork that, it locks them in because they have to either rebut it and bring forth the verification that they loaned you something of substance, okay? Or it's fraud, because if they didn't loan you something of substance, well, where did what they loan you come from? Since they can't loan you their customers' proceeds
and their own
credit. So, it came from you. So what really happened is you did a banking transaction under the GAAP, and whatever bank they took it to, they deposited it, and it was probably deposited in a transaction account in your name without telling you, and then it was withdrawn from that account. So when it was deposited, there's the asset. According to GAAP, there's a liability. When it was withdrawn, there's a liability, and that zeroes out that account. That also paid, well, it covered the cost of the house. Okay, that's where everything came from. And then they turned around and sold it at a discount. Probably took it to the discount window at the Fed. And then, they bundled it up and put it in investment, REITs and these trusts. And so they've made, 3 times what they charged for the house right there. Okay. And then they want to come and say, okay, we're going to take it and foreclose on you. But they don't have the necessary documentation to be able to start the foreclosure, but most people don't know it.
Right. So remember, very important takeout from this video is that you need to be requesting the original documents. They need to basically provide the evidence or provide a showing of that they hold these documents in their original form. Because like we said, you cannot make a check, give it to someone, and make a copy and keep giving this check to other people. All right? That's fraud. That's counterfeiting, all right? So that's exactly what they are doing, and they are hoping that you will never be asking these kind of questions, right? Because it's all built on intimidation, coercion, and just general ignorance that people just do not know what's really going on. And what is really sad is, and we did video on that too, is that these mortgage companies, they create a whole organizations, all right, where they are miseducating all these employees to basically play a part in this fraud, right? So they don't even realize what's going on, and they might be good people. They think that they are helping people into their homes, right? But no. We've had, oh my gosh, those discussions we've had with all these reps at these companies, and it goes beyond their comprehension, okay? Because they've been so indoctrinated that these mortgage companies they are loaning something to the people.
Yeah. Yes,
but that's, once the fraud is exposed, and once and once you've been educated, and maybe this is why they don't want to give us their last name. What do you think, Doug? They never want to give us. They have these funny names.
That shows guilty knowledge. It shows that they know that there's something wrong, because when we ask them, they'll give you their first name and then XYZ or, ID number 8822, or they won't give you the last name. And so, when Linka jammed them on it and said, well, look, you got all my information. Why can't I have your last name if you're honorable? And they said, it's for security reasons. Well, what is it that you're doing that would make people want to hunt you down and harm you, dude?
Right?
Like, what kind of business are you running where you can't give out your last name, even though you've got people's social security numbers,
where
bank
they
account,
live,
all that? Tell me how that makes sense.
You see?
Okay, tell me how that even. I mean, if I worked for a company and they told me, hey, you can't give out your last name for security reasons. You never know what somebody might want to do to you. I'd be saying, well, check it out. Either you're selling a bunk product, or you're doing something that I don't want to be a part of. So,
right.
Take that somewhere else, man. If I can't do business and give my last name,
Because, for example, one of these letters, we've seen just recently is basically a threat and coercion, intimidation with starting a foreclosure procedure, right? And it's total bogus letter, which of course is not signed. There is no name of man or woman, and so you call them up, right?
Customer care team.
Customer care team. I'm like, okay, I want to know the specific name, full name, first name and last name of the man or woman who created this letter, print it out, put it in an envelope, and use the United States mail to be delivered to me. I need to know, because I will hold them liable in their personal capacity for just the mail fraud alone, okay? Because they are using United States mail to conduct criminal activity, which is a federal offense. And it's very interesting. When you ask them, suddenly it goes silent, because of course, they don't want to give out any names. And this is exactly why, because they keep producing and spitting out all these letters that you get, right? They look official, but they are all bogus.
They have 2,200 employees, okay? And the way that they have it set up, they have these different teams. Mm-hmm. So anytime you call and you explain it to, these different teams, okay? And they're supposed to take care of it, and they don't, and you call them back, you have to re-explain it, because you never talk to the same one twice. And that's done intentionally. And they don't give you the last name, so you can't really identify them. Okay? So, I mean, it's a criminal organization right from the top. They're trying to hide their identities to save themselves from being liable for the stuff that they're doing.
Right. And if you are working for one of those companies, you need to start questioning. You need to start asking your boss, Mr. Smith, I really need to know what's really going on that someone would want to come after me if they know who I am by identifying myself with my full name. I really need to know. I need this to be explained to me. For what kind of security? What kind of security it is? Because you see, the way how business used to be in America and just anywhere in the world is, on personal basis, right? You know me, I know you, and we are doing honorable business, right? I sell you services, I sell you product, you pay for it, and we know each other, and it's based on trust. It's based on honor, right?
Honor and good faith.
And good faith. So what happened? What happened to our mankind interactions between us, that I am dealing with someone who has my social security, my full name, my complete financial information, plus they know where I live, and I cannot even have their last name?
You're not dealing with men and women. You're dealing with
persons
and
That's right.
and different entities that they don't have, they don't have their own will that they can do while they're at work. Yeah. They've been programmed so that they have to do exactly what they're told and what they're programmed to do.
The corporate bylaws.
The corporate bylaws.
Yeah, you need to be a criminal. You need to play criminal. From Monday to Friday, from 9 to 5, you are part of our criminal enterprise. And this is why, for your own security reasons, you cannot give out your name. Plus, I think that even their first names are kind of sounding funny most of the time.
Well, it's kind of funny because you get these automatic calls, and they give you the full name of this so-called agent that you're supposed to contact at this number. And when you call in, you can't ever get that agent on the phone because that agent doesn't even exist. It's something that they just made up because the policy is they can't give you a last name. So how are they calling up and saying, hi, my name is Sean Conkery, and you need to call me at this number right here. I can be reached, Okay. Yeah. The dude don't even exist.
Guys, so start asking questions, start researching, start connecting the dots, and thank you for watching, and we will see you in the next video.